Hi, I'm Alex Loftus. I'm a chair of the Stoltman Law Office's Commercial Litigation Group. I'd like to talk to you today about alternative fees in defense of cases. Now, most of what alternative fees are is really we're just talking about a contingent fee where if you win, we win, and we collect from the defendant. Now, the other place where we use contingent fees and success-based fees is in defense of cases. Now, few attorneys are able to do this, but here at Stoltman Law Offices, we've handled so many cases just like yours, we have a good idea about how much work it's going to take and how much it's going to cost. So, with the way a normal attorney-client relationship works in a commercial setting is you pay the $10,000 retainer, and then the attorney finds a way to bill as much as possible, as fast as possible, and generate this huge bill that's hanging over your head. And then as litigation goes on, you owe your attorney $100,000, you owe him $50,000, and you work out some kind of a monthly payment plan. And then meanwhile, as you litigate the case, you're hesitant to do anything aggressive because then it's going to cost more money and add to what you already owe your lawyer. And it's this awful situation where the attorney starts off doing as much work as he possibly can, and then the two of you are trying to find ways to avoid work, even though it's not what it takes to win your case. Now, Stoltman Law Offices, we know how that hourly game is played, and it doesn't work. So instead, we get a thorough understanding of the case before we get in. We evaluate all the different aspects of it and figure out how much work this is going to take. And we figure out that this case is going to take $50,000 worth of work. It's going to take $100,000 worth of work. And then we assess about how long it will take to resolve. With that thorough understanding of the case and understanding the mechanics of the court process, we're able to quote the client a monthly flat fee to defend their claim. And then generally, when defending a case, your goal is to get it over with and get it over with as fast as possible. So to go with the monthly flat fee, we create some sort of incentive plan. Whether it's if the case is resolved via motion to dismiss, then you pay a bonus. If the case is resolved via summary judgment, then you pay another bonus. We figure out some way to give us, the attorneys, a carrot to get it done quick, so there's no incentive to drag it out. So what ends up happening is you commit to us to pay a fee that you know you can afford. There's no unforeseen risk. There's no unforeseen additional fees. But you're locked in at a flat monthly rate. We know, because we understand the business and we understand the case, how much work it's going to take, and we take the risk that it's going to be outside the bounds of what we forecasted. So what ends up happening is we can take any aggressive action we need to defend a case. That's why, for example, few lawyers will respond to a complaint with a motion for summary judgment. Why don't they do that? Because you can't bill more by the hour if you end the case right away on summary judgment. Now, on our creative fee arrangements, we can take on the big task of a motion for summary judgment in response to a complaint to end it right away. And we work together on the fees that the lawyers can make money and the client can win the case. This is a new way of practicing law, a new way of charging for defense, but that's only because of the last 30 to 50 years that the business has changed. In the days of Abraham Lincoln riding the circuit, he would sit down with the client and they would charge a flat fee for the entire case. And the lawyer and client work together and say, well, this is a $5 case, this is a $10 case. So really what we're doing is going back to the roots of practicing law. And even in defense situations, even in cases where there's no potential counterclaim, there's no potential recovery, we can work together to achieve a fee arrangement that we both win. The other option, in addition to flat monthly fees for defense, is essentially a reverse contingency. So what we do is we work with the client in a case where we know they have liability and the client knows they have liability. And we set a target settlement amount. And then in addition to some monthly fee, we agree that if it settles for less than whatever our target we agreed on, that's the attorney fee. So then we have an incentive to get the case done quick and get it over with quick. And if there's legitimate liability, pay the plaintiff quick. The goal is to end litigation. And we can achieve that goal of ending litigation as fast as possible, as aggressively as possible, through these alternative fees. So if you'd like to learn more, contact Stoltman Law Office's Commercial Litigation Group at 312-332-4200.